Hey, my friends, how you doing? I've missed all of you folks. I'm happy that in the past month that we've been off, I did hear from a lot of people and a lot of suggestions about what we could talk about. So that's always great. I hope that your New Year is off to a good start. I will say on my end, my mother-in-law passed away 2 weeks ago. So the family and I have been dealing with that, and my wife is, she and her mom are very close. So, but of the many wonderful things about that sweet lady is she loved my mother-in-law jokes. She loved them. Like, she encouraged me to always have mother-in-law jokes. So that was pretty funny. And coincidentally, I did hear a mother-in-law joke over the last month. This guy and his wife and his mother-in-law go visit the Holy Land, right? They go to Jerusalem. And then during the trip, the mother-in-law dies in Jerusalem. And then they're going to kind of bury her. And, one of the morgues or whatever says, you can, if you want to fly her back to the United States, it's going to cost $8,000. But you could bury her right here in Jerusalem. It'll cost $400. So $400 as opposed to $8,000. And the guy looks at him and he goes, he gives him $8,000 cash right away. And the guy goes, why are you spending $8,000? You could just bury her here in Jerusalem for like almost free. The guy looks at him and says, you know what? I don't know if you know the story, but about 2,000 years ago, a guy died here in Jerusalem and came back to life. And I want to make sure that doesn't happen again. That was a good joke, huh? Yep, my mother-in-law, God bless her, she used to love all the mother-in-law jokes and stuff. All right, so today we're going to be talking about something that's not a joke. The 14th Amendment and Donald Trump running for president. The state of Colorado banned Donald Trump from being on the ballot in the primary candidates, for president. And this is crazy to me that he was banned in Colorado, and then he got banned in another state, and then in the state of Michigan, there was a push to ban him there, but the court in Michigan said, no, we're not going to do that. In California, Governor Newsom straight out said, I am not going to ban him in the state of California to run for president. So here, and then finally, the United States Supreme Court decided to kind of, when they have all these split and decisions in different states and different jurisdictions, a lot of times, especially if it's an important enough subject, the United States Supreme Court will take it. And it is this case, Colorado banning him, saying that, no, it's a violation of the 14th Amendment because he engaged in an insurrection. And so therefore he does not qualify to become president again. The case has so much issues that are going to be fun to discuss, like constitutional issues and kind of the history of the 14th Amendment and how it came out after the Civil War and this application. And I'm going to come out and just say it right away. The Colorado Supreme Court messed this whole thing up. I think they're dead wrong about this. I think the United States Supreme Court is going to freaking give them the caboose and just say they're flat out wrong. And to get there, though, it's kind of a complicated process. It's a lot of fun. And we're going to have, as always, I hope, we're going to have a lot of fun. And in the meantime, you'll learn about civil litigation, civil procedure, constitutional law, the history of these different constitutional amendments. Okay, so let's start with what exactly happened. So, as you know, so Donald Trump was the president from 2016 to 2020. And then Joe Biden won the election in 2020. And then, he's supposed to become president in January 2021. Obviously, Donald Trump disagreed that Joe Biden won the election. And he said it was rigged. It was flawed. There was, everyone knows the story, right? And then there was a push to disallow the Electoral College to kind of like move along, and he was trying to get Vice President Mike Pence to not sign off on the election, and that could have been a disaster and confusing time period in our country. And, who knows if the presidency would have switched. I mean, it was a weird time, right? And this is what Colorado used as a basis to disallow him from running for office. Okay, so now we got to kind of explain how all this happened. So there was a civil war in our country in 1861, right? And then after the Civil War, right, the Union won, the North won, the Civil War. And when I used to teach law, I always used to say, like, if there's like a federal law and there was an issue where there's a difference, like a federal court said one thing, the state court said something else. And I said, well, the federal law is the authority. And why? Because the Union won the war. I used to always say that, right? So that's why the federal government is the supreme one here. So, and then after the Civil War, the 14th, there was a few amendments that were passed. One of them, like the 13th Amendment, the slavery, the 14th Amendment, which is the one in question here, the 15th Amendment. So in the 14th Amendment, they said, like all of these different discriminations are not allowed, and that all anything, depriving someone of their rights can only be done with due process, and no state can violate the other amendments. Because before the 14th Amendment, the First Amendment, Second Amendment, Fourth, Fifth Amendment, a lot of courts interpreted that only applies to the federal government. So the states can take away free speech. The states can do whatever they want because the Constitution, those Bill of Rights didn't apply to the states, but the 14th Amendment made it apply to the states. And then there was a section in the 14th Amendment, something that has never come up since the Civil War. And that was this Section 3 that says, the short version says, no person shall become an officer of the United States if that person engaged in insurrection or rebellion against the United States. Okay, so there's a little section. I gave you the short version of it. The reason why that was in the 14th Amendment was because after the Civil War, in the states that seceded from the Union, there was a lot of officials there that were either previous Congress members or senators. They were, other federal officials and things like that. So, and then those people are the ones that wanted to secede from the Union, that fought the Union, that said, we're part of the Confederacy. We're no longer part of the United States. And the federal government put this in there because they didn't want those people, right, to regain their office. Because what are they going to do if times get tough? They're going to try to secede from the Union again. You see what I'm saying? So they didn't want them to run for office. So that was the history of this Section 3 of the 14th Amendment. And it hasn't come up for the most part since then. And then we got Donald Trump. And now it comes up. All right. Then, so Donald Trump was the president. He lost in the 2020 election. And then now he is running for president again in 2024 for the 2024 election. And for him to win, obviously, he has to be on the ballot, first of all. And the state of Colorado, the Supreme Court of the state of Colorado ruled that because of this Section 3 of the 14th Amendment, he does not qualify as a candidate for president. Now, to get there is when I talked about earlier, all of these different constitutional issues. Okay, so who challenged this were a group of voters in Colorado. So these group of voters in Colorado said, wait a minute, the Secretary of State of Colorado is putting Donald Trump on the ballot, this insurrectionist, and that's not proper. So they filed a lawsuit in the state of Colorado to prohibit him from being in office or as a candidate. All right. So the first order of business, jurisdiction. Okay. Donald Trump's attorneys filed a motion to remove this from the state court to the federal court. And the federal court said, we're not going to take this case because these voters have no standing to assert any of this. Now, this is another kind of constitutional issue. This thing about standing. Standing in constitutional law basically means if a person is allowed to even file this lawsuit. Like, I'll get a call from friends or clients or something saying, "Oh, this isn't fair. California is taxing this, or I don't like how this guy shouldn't be the governor because he didn't do this properly, or blah blah blah." Right? So a lot of times, this issue of standing is who is allowed to file a claim, or if the United States government goes to war, and then all these people are like, "Wait, the president exceeded his authority, and I'm a taxpayer, and my tax money is going to the president who exceeded his authority by engaging in this war," and blah, blah, blah. So the idea of standing is ordinarily a taxpayer, just by being a taxpayer or a citizen, doesn't usually have standing to even assert those claims. It has to be something, if there's a large group, maybe they'll have standing. If they're asserting something for like environmental protection, like the wildlife protection conservation groups, or the Sierra Nevada. Is that a beer, or that's the Sierra Nevada, the environmental group, right? So anyway, there's all these different groups. So sometimes they'll have standing as kind of these big organizations. But that was the first issue. So the federal government said, we don't even want to take this case because these taxpayer voters don't have standing. So then it goes back to the state court. And that is one of the first issues. The state court has to decide, do these voters, because the state of Colorado, like the elected officials and including the Secretary of State that kind of runs the elections, they did not ban Donald Trump from running. So no government officials banned Donald Trump. We just had a group of taxpayers, basically. That's the first issue. The Colorado, how it went down was, first, this was in a trial court in the Colorado District Court. That's the trial court. The trial court said that these taxpayers do have standing to bring this case because they are voters in Colorado and they have standing as voters to bring this case. The Colorado Supreme Court on appeal upheld that. And that one is my first kind of, that could have went either way. I think that it is not proper that they would have standing. But apparently I'm wrong. There was the dissenting judges in this opinion in the Colorado Supreme Court would probably agree with me, or they did agree with me. But the majority of the judges said that these taxpayers do have standing. That is a shock to me. But they did it. I think it opens up a big kind of deal in the sense that you get like a small group of people, you could challenge almost anything. In theory, that's kind of cool, but the problem is it'll. I don't know if the whole idea is people elect government officials, right? And the government officials then make these political decisions. And so if you constantly have the court intervening when a taxpayer doesn't like something, then you're going to have, for something to pass, you have to have the politicians, the government agree, and then the court. Those few people that disagree, instead of them doing things the political process way of getting new officials elected and voting for certain things, they'll just challenge it in court. So I think that's a no-no. And I think the Colorado Supreme Court screwed that one up. And I think the United States Supreme Court will go after them for that. Then the next order of business is this concept in constitutional law called ripeness. Okay, ripeness means for the court to get involved, there has to be an actual case in controversy. Like it has to be, there. It would be kind of like if I was to file a lawsuit saying, I think that this stadium will one day be too loud, and I live in the neighborhood and it's going to be too loud because it's growing in popularity, and in 10 years from now, it'll be too loud, maybe. So the court can't take that case because they'll say, well, it's not ripe yet. Like, let's see if that happens. Otherwise, we're going to be adjudicating cases where, there's not a real controversy yet. So Donald Trump's attorneys made the argument that, well, this case, he's just running for office. He didn't win. So this is like too early. Like if he wins, then we could decide this case. But if we decide this case and he doesn't even win, we will have wasted all these judicial resources. Do you see what I'm saying? I think that one is okay. Maybe it's ripe. So I won't take the Colorado Supreme Court to issue too much there because he put himself on the ballot. He's a legitimate chance of winning. So I think that one, okay, it's ripe for decision. But they could have lost on that, but they didn't. So that's another kind of for folks out there that I remember when I studied constitutional law, I mistakenly thought that everything's going to be like, the First Amendment, this and unreasonable search and seizures and Miranda warnings and blah, blah, blah. But the whole first semester of constitutional law was all these different procedural things. So if you want to be a constitutional law attorney, it's all these procedural things that you have to adjudicate first before you get to the substantive issues. Okay. So the court there ruled that no, this whole thing is right. Then the next issue is who is making this decision? It's the state of Colorado. Now, the Donald Trump attorney said that the state of Colorado cannot decide who can be on this ballot because it's a federal election. Not a state of Colorado election. All right. You with me here, Mateo? Okay. So that's a good argument. If someone's running for governor of Colorado, then the Colorado state would determine if this person, meets the requirements. If someone is running for, the senator for Colorado, so he's going to represent Colorado in the Senate, then I think the state of Colorado has the authority to kind of say, okay, who qualifies and who doesn't. Now, this one is a pure federal office, right? This is the president. So I think that the state of Colorado does not have the authority to determine if Donald Trump is a valid candidate or not. I think that one, they overstepped their constitutional authority there because, like I like to say, who won the Civil War, Zeke? The North, right? So the federal government is supreme here. And I think if it's a true federal government office, then the federal government has that decision, not the state of Colorado. The state of Colorado said, of course we can decide who's on the ballot in the state of Colorado. It's our electors and it's our state that can vote and blah, blah, blah. If the guy was 28 years old instead of 35, this is the Supreme Court's opinion that I'm discussing, the Colorado Supreme Court. If he's, if he doesn't meet the age requirement or if he's a foreign national, because he has to be a natural born citizen. But if he was born in a different country and blah, 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 of course we could ban him from the ballot. My opinion is that was exceeding their constitutional authority. I think they screwed that one up also. I think that if it is something like clerical or an age issue, then they could, they could disqualify him if it's like on its face, there's something wrong here. But if it's something, especially if it's a gray area, and the Congress or the federal government isn't blocking this, then I think the state of Colorado can't do it. All right. Obviously, I was incorrect. I am of the dissenting opinion on that. Okay. Now we get to, especially because the idea of the Section 3, remember, it had to do with the federal government after the Civil War. So it would have been crazy if the states are the one that can decide who's running for these federal offices, especially because the whole idea was after the Civil War, we didn't want the states to make those decisions. That's why, so I think Colorado exceeded its constitutional authority in that respect. Okay. The next order of business, I love one of the things I love the most here is when attorneys they read a like specific language in a law or in a statute and say, well, technically the statute says this. This one is one of my favorite ones. Okay, so the 14th Amendment, Section 3 says, no person shall be a federal office, who having previously taken oath, or executive to support, have engaged in insurrection. Okay, so here it's saying that no person shall hold any office. So Donald Trump's attorney said, well, the technical amendment said no person shall hold office. It didn't say no person shall run. You know, do you see what I'm going here? So they're saying, well, technically, he could run for office even if he can't hold it. And there is, those are very funny. Even, you know, how they say, like, no president should be elected more than twice, the term limit of twice. So there are these scholars that say, well, then technically somebody could be president for 2 terms, then he could be vice president because he didn't run for president. And then if the president dies or resigns, that person becomes president because technically the Constitution only says he can't run for office more than twice, or he can't win office more than twice. So here it's saying he cannot hold, even if it's true he's an insurrectionist, he can't hold the office, but it doesn't say he can't run. It's kind of technical, right? Some judges dig those technical definitions. These judges said, no, obviously if he can't hold the office, then he can't run, because otherwise you're going to have a 28-year-old just run for the heck of it. You know who did run for office and change his name? And it was like a funny thing. This guy, you guys remember D's Nuts?
These nuts. Got him.
There was a guy that started running for president under the name D's Nuts, and he was actually getting a lot of votes. Did you vote for D's Nuts, Zeke? No? Yeah, right. I think Zeke voted for D's Nuts twice. You know, I mean, he was an official candidate for president. Anyway, okay. So the Colorado Supreme Court is saying if he can't hold the office, we're not going to let him run for office. Okay, that one, you know, could have been iffy. You know, fine. I won't take them to task there because I see the point here. Now, the next order of business that the Donald Trump attorneys point out is that Congress did not, and I kind of mentioned, you know, this a little bit, Congress hasn't made any sort of decision on this, and Congress did not issue anything saying that he's an insurrectionist. Right. And they didn't forbid him from running. So if Congress doesn't do that, then the state of Colorado can't. To which the Supreme Court of the state of Colorado said that is incorrect because we do have the authority in our own state to determine if somebody can run for president, and that we won't let our electors. Is it electors or electors? It's spelled electors, but I kind of, you know, a lot of people say our electors. We won't let them vote for him. So they said to that. And then they also said this, which I think is interesting. They said, well, Section 3, you know, it just says no person shall run for office if he's an insurrectionist. It doesn't say that. Okay, so Donald Trump's attorneys said it doesn't state that a state can make that decision. And then the Supreme Court of Colorado said, well, it also doesn't state that a state can't make that decision. Do you see what I'm saying? So it's silent about that, which happens all the time in law, because it's like it's hard to have every single kind of contingency written in there. So that the state of Colorado said, well, because it doesn't say that only Congress can make this decision, then we are interpreting the amendment to mean that a state could make that decision also. I think that is inaccurate myself. All right. Then the Donald Trump attorneys, it gets a lot better. Like, in fact, this whole thing is going to keep getting a lot better. I dig this whole thing. Okay. The next order of business here. In 1994, Congress specifically made a law about insurrection. And that law was, so it was passed in 1994. And it says, this statute makes it a crime to assist or engage in any rebellion or insurrection against the authority of the United States. So that Congress passed this law in 1994, and it had the exact kind of words, right, that this amendment has, and it had definitions of what counts as an insurrection, what counts as a rebellion. And I think back then, you know, in the 90s, it was just people were worried about like some sort of spies or espionage and things like that, or whatever it was, right? They just happened to pass this law. And then, and this is true, that President Trump, of his several indictments, okay, I'll tell you, here's a trivia. What's one thing he never got indicted for? Insurrection, okay? So there's a federal law on the books, okay, for this exact crime, okay? And Congress hasn't charged him with it. And the federal government hasn't charged him with it, even though the federal government charged him with other violations, like he wasn't supposed to do this in the election, he wasn't supposed to do that. They never charged him with insurrection, which is, so he's saying, his lawyers, Donald Trump saying, if the federal government didn't even charge me for insurrection, then you cannot make a decision that I am an insurrectionist if the federal government didn't even charge me with it. You with me? I like that argument. I think it's a good argument, but I'm wrong, right? The Colorado Supreme Court decided that no. Again, they said, well, if the federal government did charge him and did find him guilty, then he would be disqualified. But that's not the only way somebody could get disqualified. We could find the same thing ourselves. All right. I am obviously in disagreement there, but again, okay. Another funny one was the next one was that he's saying in the Constitution, in that amendment, it said that nobody can hold office, under the United States. And then they're saying, well, the president is not under the United States. He is the United States. So that one, I think the Colorado Supreme Court is okay there. They're saying, no, what they meant by under the United States, meaning like, under a part of the federal government. Okay, that was another one of those technical ones. Okay, the next order of business that they say that this is a political question, not a legal question, meaning that the whole fact that people could vote for the president and that they could vote for him or against him, that this should be left up to the political process and not the legal process, because the last thing you want is for the people to elect a president and then a judge saying, no, I'm going to disqualify him, even though he's the right age and he's, a natural born citizen. I'm going to disqualify him. What if 95% of America vote for Donald Trump, right? And then all of a sudden you have a couple judges that say he's not, qualified. That would be a disaster, Donald Trump's attorney says. But they lost that one. I think that one was okay to lose because the Constitution is saying these particular people are not, if they're an insurrectionist, they can't hold office. And the whole point is that so that, you can't have the majority, it's kind of a check against the majority. So the majority can't, if they want an insurrectionist in office, they can't even vote for him, So that one, okay, I see the point there, that was okay. Now, finally, can we talk about if he's an insurrectionist or not yet? Notice how this whole time we haven't talked about it yet, And it wasn't until about 80 pages into the opinion that they started talking about it. And my favorite thing was as soon as they talked about the substantive issue, then they started talking about procedures. You like that? Okay, so there was, get this. So finally they say, okay, if he's an insurrectionist, we're not going to let him run. So now they have to adjudicate whether or not he's an insurrectionist. How the heck they're going to do that? They had a 5-day trial. All right, a 5-day trial. And in that 5-day trial, they didn't have many witnesses. All they did was that they used Congress's committee reports. And they, which in rules of evidence, what they, that is, I think and Donald Trump's attorneys are saying this on appeal, is that, wait a minute, you just had a trial where you didn't bring in witnesses, you didn't have a jury, you didn't have like you didn't even have a fair trial, you just claim, so he's saying that, and then that rules of evidence, it makes sense because the Congress what they did was, do you guys remember this like little committee that they had at Congress? It made sense. It was a majority of them were Democrat Congress members because the Republicans didn't want any part of it, and most of them boycotted it. Maybe there was 2 Republicans on it, and most of everyone else was Democrat. So he's saying that it was a biased committee. Then he's saying that in the committee itself, they based their conclusions on a lot of hearsay evidence, like. Mark Meadows said, yeah, I don't think Donald Trump wanted to stop the violence, or I think this, I think that. So the whole report was based on potentially inadmissible evidence, right? Because if you're going to, for example, if you're going to convict somebody of murder or arson or drinking and driving, things like that, you need to have a jury. You need to have proper evidence, right? And none of that happened here. So they're saying that the procedure of how this trial determined that he's an insurrectionist was not fair. I think that's a good argument, but apparently I'm wrong, right? Oh my goodness. I think that's a good argument because if you deprive somebody of a substantial right, it has to be with due process. Coincidentally, that's in the 14th Amendment in Section 1 and in the 5th Amendment. So how can you deprive? This is a big right to deprive somebody of running for president of the United States. So to deprive him of that right, I think he should have a trial. I mean, freaking, if somebody gets a DUI, they're entitled to a trial. And that's, even if the jail time is very little, or whatever it is. And if you sue somebody for freaking $50,000, you're going to get a trial, a jury trial. So I just don't understand how all of this, the Colorado Supreme Court said it is not a violation of his due process rights to kick him off the ballot without a jury trial and without, or with these like kind of shaky rules of evidence, hearsay, schmearsay. They didn't say that. But they did say, there's all these exceptions to hearsay rules, and this big congressional report is an exception because it's a government report and it's an exception to the hearsay rule. That is just crazy to me. Like in a trial, like when I'm in a trial, it's like any little thing that I want to say, did you see the red light? Like I can't even ask someone, did you see the red light? I have to say like, do you have good vision? Do you know what a traffic light is? Do you know the difference between a red and a green traffic light? Can you form an opinion about something like that? Blah, blah, blah. And then I could ask him, with the effing light red? So I don't understand how all of this came in without all of that, that kind of the evidence. But they said that it was all allowed. Okay. All right. Can we finally get to whether or not he committed an insurrection? Yes or no? Yes. Okay. Finally, all these procedural things. That is one of the things as a lawyer I always remember. I'm like, oh my God, before we even talk about the dispute, because the whole flipping thing says if he's an insurrectionist, he can't run for office. So finally, after all those procedural things, we could talk about if he's an insurrectionist. Now, what the court said here, this is like I said, it keeps getting, better and better. The court said, well, at the time in 1860, they didn't have a law that kind of defined what insurrection is. And so to get the idea of the framers of the 14th Amendment, we want to know what insurrection is. So you know what they did? The Colorado Supreme Court, they went and looked up the Webster's Dictionary in 1860 to see how the Webster's Dictionary defined the word insurrection. Theory being that was the common usage of the word, which in law, that's like the last resort. It's like, it wasn't defined in the statute. It wasn't defined in a law. It wasn't defined in the Constitution. So let's just see what the dictionary says. The Webster's, which by the way, remember when we did a thing about new words in the dictionary? Like Riz and sup, and what were some of those funny words that, this is the Webster's Dictionary, right? So this is what we're using for the authority here, okay? So they go back and they say, okay, an insurrection, a rising against civil or political authority, a rising, the open and active opposition of a number of persons to the execution of law in a city or state. It's equivalent to sedition, except that sedition expresses less extensive rising of civilians, okay? So it's kind of like this uprising, and that was the definition. And then they said So they're kind of like going back over all of these old dictionaries, and they're piecing together what an insurrection is. They finally come up with the following definition. We think, the Supreme Court of Colorado says it's a public use of force or threat of force by a group of people to hinder or prevent execution of the Constitution. So a public use of force. Now, the next order of business is they're trying to decide, okay, did he commit this insurrection? And what the district court in this little 5-day trial adjudicated was that the events of January 6th constituted a concerted and public use of force by a group of people to hinder the government from electing the next president. It said the mob, the January 6th mob, was coordinated and demonstrated a unity of purpose. They marched through the Capitol building chanting in a manner that made clear they were seeking to inflict violence against members of Congress and Vice President Pence. They go on and start quoting Donald Trump's tweets back then, and certain things, like one tweet he said in December 2020, swing states that have found massive voter fraud, which is all of them, cannot legally certify these votes as complete and correct without committing a punishable crime. So this is Donald Trump. They said that when Donald Trump said, we got to fight for this, we got to fight like hell for this, right? Donald Trump always said, well, I meant like fight like peacefully and challenge this. The Supreme Court calls it no. Far-right extremists and militia, such as the Proud Boys, Oath Keepers, and the 3%ers, viewed Donald Trump's tweets as a call to arms, and they began to plot activities to disrupt the January 6th thing, And then another tweet by Donald Trump: if a Democratic presidential candidate had an election rigged and stolen with proof of such acts, the Democratic senators would consider it an act of war and fight to the death. Mitch McConnell and Republicans do nothing, just want to let it pass, no fight. So what they're saying is his tweets kind of, remember I said that definition of insurrection, kind of like an uprising, a call to arms type of thing. So the Colorado Supreme Court is saying that these tweets and his manners and how he was saying all of this amounted to this insurrection, this kind of like call to like a violent overthrow of the government. They cited his speech. Remember that January 6th speech in the cold weather and all that? Remember that, Mateo, right? We're gathered together. This is Donald Trump. Should I do the Donald Trump voice or just say it real quick? What do you think? Mateo's just like, whatever gets us through this faster. All right, thanks, Mateo. Okay, we're gathered together in the heart of the nation's capital for one very basic reason: to save our democracy. Republicans are constantly fighting like a boxer with his hands tied behind his back. Now it is up to Congress to confront this egregious assault on democracy. We're going to walk down and we'll be there and we're going to fight like hell and we're going to, blah, blah, blah. And we fight like hell. And if you don't fight like hell, you're not going to have a country anymore. So the Colorado Supreme Court is saying that he started this violent uprising, and that is an insurrection akin to the Civil War, right? And it is so bad that we are disqualifying him from running for office. The Colorado Supreme Court had judges who dissented, meaning they disagreed with the majority. I've always thought that was funny. These guys are Supreme Court judges, right? And dissenters are basically saying, you don't know the constitutional law. You fail constitutional law. You know what I'm saying? Like either it's the law or not. But anyway, only in law can you have, theoretically, if somebody has a dissenting opinion, they got it wrong in theory, but they're still getting paid, right? The dissenting opinions just basically echo some of the things that I said. And I only want to, I don't, they basically just said what I said, darn it. But I did want to mention, I freaking made sure of this. I didn't want to forget this one. So this one, Justice Samauer. The name starts with the letters SAMO, but that's a pure coincidence, okay? Anyway, all right. But my favorite one is this: said, Our government cannot deprive somebody of the right to hold public office without due process of law. So kind of like, well, one of the things I said before is that you're depriving somebody of such a big right. And it's always the case. The bigger the right you deprive someone of, the more the more legal procedures you should do to make sure that you deprive them of that right fairly. So if you deprive somebody of a parking ticket, and Mateo, you've gotten a lot of parking tickets, $100 they deprive Mateo of, that's not a big deal. He's not going to get a jury trial. But if you deprive somebody of, the right to become president, that's much bigger. And I think he should have a jury trial and all those things, What do we always do at the end? By the way, I'm not a Trumper. Like, I don't care. I'm not a Trump fan or anything. I just think that that this was done wrong. I think the United States Supreme Court is going to reverse this opinion, and they're going to let him run for office. Good work today, my friends. I'll see you next week. Oh, please let me know what you think.